Making good his promise, Dr. Bukola Saraki appears before the Code of Conduct Tribunal, sitting in Abuja. He arrives in company of his supporters, particularly his colleagues at the Senate. His appearance again sparks off another round of legal battle over attempts by the Senate President's lawyer to stop the proceeding.
The Code of Conduct Tribunal is never conceived as a court by the Constitution, and no legislation of the National Assembly can empower it to act as a court or dress it with judicial powers, which are only meant to be exercised by the courts created by Section 6 of the Constitution. This conclusion has solved most of the nagging problems yet to be answered in this case. Since the Code of Conduct Tribunal is not a court and has no power of criminal trial, it cannot issue any warrant for the arrest or imprisonment of a person under any guise. In fact, the power given to the tribunal under paragraph 18 of the 5th schedule of the Constitution does not extend to ordering the arrest or detention of any person who contravenes the Code of Conduct.
The provision of this Act, that is the Administration of Criminal Justice Act, shall apply to criminal trial for offences established by an Act of National Assembly or other offences punishable in the Federal Capital Territory, Abuja. So, my lord, that Act on its own said any court administering criminal justice system in Abuja should apply it. It says so. And the only exception is the subsection 2. Say the provision of this Act shall not apply only to court martial. So it's only court martial that say no, we cannot apply it. My lord, your lordship ruling yesterday, a party cannot come and say she will revisit your ruling of yesterday. I'm not agree with it. Reopen argument. That is what the Legal Council has done this morning.
In the end, the Senate President is docked owing to the ruling of the chairman of the tribunal against the defense team. Mr. Bukola Saraki pleads not guilty to the 13-count charge of corruption and forced declaration of assets at the Code of Conduct Tribunal.
Not guilty.
After the plea of not guilty has been taken or no plea has been made, the prosecutor may open the case against the defendant, stating shortly by what evidence he intends to prove the guilt of the defendant. Yes. So, my lord, that is what I'm expected to do, and also under your lordship's the rules of this court, apart from Administration of Criminal Justice Law. Yes. I intend to discharge my duty by stating briefly the evidence I want to call.
I've come here to subject myself. I believe that I'm here, strongly believe I'm here, because I am the Senate President. I don't believe that I'll be here if otherwise. Mr. Chairman, I want to say that I observed that we made reference to some of the good work the Senate has done in the criminal administration. The same Senate was the one that passed the Code of Conduct Bureau Act of 2001 that clearly states in Section 3D that I just want to make these opening remarks to show that I believe in the rule of law. Section 3D says there that if there is a breach of the asset declaration, the Code of Conduct Bureau shall refer the matter to the Code of Tribunal after giving the person an opportunity to either confirm whether those facts are true. And if he admits, the matter shall not be referred to the tribunal.
Mr. Defendant.
Well, I will now go ahead because I want to explain why, Chairman, I will now go ahead and accept. I just wanted to state that for you to understand as a layman why I'm puzzled why I should be before the tribunal. I thought that the Code of Conduct should have first called me according to the law, because we have been talking here about the new Nigeria. We have been talking about, especially the prosecutors, been talking about Nigeria going forward. Mr. Chairman, this is the first time, and we are all watching, we are before the new world, not before Nigeria. and we all should be seen to do. I will compare myself with the due process. And that is why I felt that before now, some of those issues need to be raised. So, as stated, I want to state that I am not guilty.
Section 36(6)(b) says, every person who is charged with a criminal offense shall be entitled to be given adequate time and facilities for the preparation of his defense. He told the tribunal that he was just coming across these charges for the first time. Ruth V. Jacob will tarry a while. Let the Constitution, let him be given adequate time and facilities to brief and instruct his legal team.
The Senate President has pleaded not guilty to the 13-count charge against him. However, he mentioned that his trial is a witch hunt.
The truth is that, you see, he said something which itself was is self-indicting. He said, I'm being tried, or I'm here today because I'm the Senate President. The Senate President is not an ordinary man. He is a golden fish. He has no hiding place. So, you can't compare me with the Senate President. As a public servant, I declare my asset too. But my own will be inconsequential. And of course, the tribunal will only hurt based on petition. Who knows, like Bukola to petition against me? 1,001 people will petition against a Saraki. So the incident, the preponderance of petition against him equally warrants or might warrant this kind of this thing. So because it's in the public eye, many people will talk about him. Many people knows what he has done right or wrong. So what he was saying is actually justifying the tribunal. So I don't know Buhari or any other people as a witch doctor. So talking about witch hunting to me is strange. The issue is that we are talking about law. He who comes to equity must come with a clean hand. As the Senate President is presiding over making laws for us, these laws, if they must be respected, are not just to be in the books. And it's a double-edged sword. You don't know when it's going to be against you. The issue is that, are you guilty or not guilty? I want Mr. Senate President to say, no, I'm not guilty, and prove that. And spare us of any of these other theoreticals.
With this recent drama going on in the Senate, what does it spell for the image of the hallowed chamber?
Sincerely, it's a good thing, but the conduct of senators too need to be watched. I feel highly scandalized seeing senators going to loaded in buses going with the Senate President. They should have a sense of shame and saying that we are solidly behind him. If they know what is good for them, they will leave Buhari to carry his can. Saraki to carry his can. This is not about the senator, the legislator versus the executive or the judiciary or the common man. This is about somebody who is being accused of misconduct, who is being accused of not being, betraying public trust. It is for him to defend himself. But when we have a situation where senators will now, as a team, as a group, we now start saying we are defending him, we are backing him, we are being persecuted, they are not doing that hallowed chamber the good it deserves. So the problem is not about this trial. The problem is about the conduct of the legislator and how they rope themselves in through a bandwagon effect into the process. But I think they can spare themselves of such embarrassment, because ultimately we've seen a lot of trials where the first thing people will tell us is witch hunting and things like that. Alam, the former governor of Bayelsa State, and quite a number of people who will tell you it's witch hunting. But along the line, you see them pleading guilty. Where do they put their step? So they should not rubbish our institution. And the legislature is a very important institution in a democracy. And I'm using this opportunity to tell the senators and every other person that they need to maintain the integrity of the hallowed chamber by distancing themselves from Saraki, because they were not there when he was making those declarations, and he was not a Senate President then. So they should allow him to defend himself. And for goodness sake, Saraki, up to now, is he presumed to be innocent until found guilty. So why should anybody now say we are standing behind him, we are solidly behind him? Are they the prosecutor? By logical inference, they are already judging him to be guilty. That's the implication. They already say he's guilty, but it's one of our person. That is not actually good for us. It's not good for the image of this country. It's not good for our democracy. It's not good for the legislator. It's not even good for Saraki himself. They should allow the man to defend himself. And I think he should be able to do that with the caliber of lawyers he has.
He's granted bail on self-recognition after making his plea. However, he believes that the case against him is a witch hunt. Before emerging the Senate president, his party, the All Progressives Congress, had anointed Ahmed Lawan for the position. But Saraki got the support of senators of the opposition People's Democratic Party.
Starting from the PDP, in the year 2000, the World Bank described the PDP as not a party but a gang of predators that are banded together by power. The same thing is applicable to the APC. This is a marriage of incompatible bedfellows. But then, for a very long time, for 16 years, they were in opposition. Buhari has contested, this was the fourth time. Atiku was there. The Saraki of this was their disgruntled element, frustrated people out of PDP. People were desperate to get power, and they were not bothered about what they would do with power. And they were not equally bothered about their ideological orientation. So they were just bothered about power. And you can see, if you look at the history of Nigerian political system, up to now, you see that the conflict and contradiction engendered by inter-party conflict is even more than inter-party. You see, what I'm saying in essence, you see people struggling more, killing themselves the more within their parties than another party, especially if it's a dominant party that is sure to capture political power. So, the crisis will continue, but for goodness sake, as long as these people still control the federal mind, the old wealth, they will still see how they paper themselves. You can see what's happening to the PDP. The PDP is now falling apart. Almost just the day before yesterday, 5,000 left and things like that in Edo State, I think. So because the power is no longer there are no political parties in Nigeria, and that's so shameful. Party is supposed to be a platform where you have people with common interests, common agenda of trying to rule a state, ideals and ideology. But in Nigeria, what do we have? There are no political parties. Nobody is educating or agitating for the common man. There is no interest articulation. There are no ideologies. What binds them together is power. And what will destroy them is that power too. And what will separate them is the power or the absence of power. That's the contradiction in the process.
The trial has been adjourned to October the 21st, 2015.